let's do the LBRY one because it's very interesting. And this is where my brain shuts down. I understand the facts in this case, but there's some stuff I just don't understand. SEC filed a complaint and filed a lawsuit against LBRY. We'll call it LBRY.
And Ripple.
And Ripple, which I know even less than LBRY, but the basis
of threatening Odyssey.
Okay. And so the basis of the lawsuit is that, from what I understand, LBRY raised funds by issuing LVC, which were library video credits or library something credits.
Like tokens, different forms of digital currency.
Digital currency, digital tokens, because this is where I'm having trouble understanding. They say we'll give you tokens, you buy them, $1 a token, whatever. You get to use them within LBRY to tip other creators, to promote stuff. I guess the one thing is, I don't understand how LBRY works, and for someone who doesn't, I mean, I understand the idea of tipping, but can you cash these credits, these tokens out for real money?
They're used as, it depends on what they're involved with, but what they are, mediums of exchange and stores of value. And the SEC is deciding to relabel them security contracts. And because if they're considered security contracts, they have to register, they have to do a report, they have to do all these things they haven't done, which subjects them to civil and criminal liability and being wiped out. And labeling anything, and the reason why the SEC is even able to do this is they went after certain digital currencies that were also selling their currencies as a form of security contract, by doing things like initial coin offerings, ICOs, and by using them solely to raise. Here's what a security contract is. In my view, a security contract should be limited to publicly traded stocks. I'd never liked the idea of allowing the SEC and their little state mini versions of the SEC regulate purely privately traded contracts for investment or otherwise. I thought that was a great overreach. The SEC should be only concerned with publicly traded stocks, not private partnership deals, basically. But that ship has sailed. U.S. Supreme Court basically said, anybody who publicly markets a contract for the purposes of profit participation, to raise money for the purposes of profit participation, is a security contract. But that should be limited to that. What they did is they went after some of these cryptocurrencies that were selling securities, and then once there was a change of administration, for the most part, decided to flip over, and they want to basically get rid of cryptocurrencies that they don't like by labeling them security contracts, which would just wipe them out overnight.
Was the token? I guess I failed to see how
the token is not a stock. You don't have any right to profit participation.
No right.
So in my view, right out of the gate, number two, it's not a contract. You don't sign a contract. You don't do it.
It doesn't entitle you.
It's not a security. It's not a security contract. Not governed by the SEC.
And obviously, no voting. No participation.
Right, none of that. I mean, this is a crazy. Their interpretation is, if you're doing anything to raise money, they even put this in the Ripple case. If you sell something, number one, two, that raises money for you, then three, it's a security contract. Well, that covers a ridiculous range of things. So the goal is simply to wipe out any digital currency they don't like. And while right now they've acknowledged Bitcoin is an exception, there's no guarantee they will constantly do that. Only the big role of institutional investors is backing them off from that. But it's a dangerous, perilous precedent. They're trying to preclude the ability of alternative mediums of exchange and alternative storage of value that, in their view, could use modern technology, and blockchain in particular, to undermine the monopoly that current state fiat currencies have in the world. That's how I see it. And legally, I don't think there's any grounds for it.
Well, I'm just brought up this super chat. We're going to get back to the context of Rappaport, because you're right. I think we didn't get it. We may have taken for granted everyone knew already. Let's finish.
Oh, right.
Okay, but so hold on. So Securities and Exchange Commission comes in. They qualify the token as a security. My question is, how is it even a currency, in the sense that how can you withdraw it for actual currency or Bitcoin or digital currency? Like how is the token digital currency if it's only good on the LBRY website?
That's still a currency. I mean, you don't have to be able to transfer it for anything else for it to be a medium of exchange. It can be a medium of exchange within a controlled environment. That's fine. It's still acting as a medium of exchange. So the degree to which you can get it for particular currencies isn't what determines whether or not it's a medium of exchange. It's whether it functions as one. Its functional role. And historically, that's what the SEC even had recognized previously with Bitcoin. If something has the capacity to act as a medium of exchange, or at least that's its functional role primarily, and secondarily as a storage of value, then it's not a contract where you're saying, give me money for my business in exchange for you having a right to participate in profits. When it doesn't have the profit participation right, it doesn't have a contractual component, it shouldn't be a security contract under the law. But they're trying to make perilous precedent in these cases, and that's why they're so risky for people who care about the ability of digital currency to meaningfully function, particularly independent alternative ones other than Bitcoin.
And now let's follow through on the hypotheticals. The SEC says this is a security. You should have registered. You didn't register. First of all, what's the process going to be like? This is a standard lawsuit, I imagine. So there's going to be
an SEC civil action. Though theoretically, if they establish this precedent, they could bring criminal cases. So because they're unregistered securities under the SEC's view, and they didn't provide material information to everyone who bought it, so there could be refunds to everybody on the monetary value of it, which would just bankrupt everybody. So that would be the net effect. That they could they could later put people in prison on criminal charges if they went that route. So it's deeply problematic if digital currencies are now called or alternative coins, and the whole alternative coin world is suddenly called a security.
And now I don't want to give anybody any ideas, but obviously this would have the same impact on tokens on locals.
Yeah, that's why Odyssey is at risk.
Okay, and the precedent to support the argument is what in law?
None. What they're trying to do is use the ICO examples. Hey, these things were called digital currencies, but they were offering the future promise of tokens in exchange to raise funds, and the future token value was based upon profit participation, at least as my understanding.
Okay,
so that was you can't relabel something that's in fact a security, just put the label cryptocurrency on it, and magically it isn't a security. In the same way, you can't magically call every cryptocurrency or any alternative digital currency suddenly a security contract just because these other ones were disguising their securities as currencies. So they're using those precedents to extend it in a space that legally has never been done before.
This would apply to game virtual coins. Yeah, I mean, I guess so. That's the extension.
Oh, yes, it has frightening expansion.
How is Bitcoin any different? Which games that you can buy to coins, purchase them? Well, how is Bitcoin not a security?
The SEC has acknowledged Bitcoin as out of this loop for now. That's the only thing. Otherwise, they can always go back and revisit it. Politically, it's because of who's involved in Bitcoin. They're not going to go after a bunch of billionaires and institutional investors. That ain't happening. They're going after people that are big enough, but not so big to really be able to fight back to the same political scale Bitcoin backers could.
Amazing. And these are hefty fines and potential criminal infractions.
And it's basically a way to take out entirely the ability to operate a government unapproved alternative currency. That's kind of how it's really working, in my view, and storage of value that potentially threatens the monopoly that the state fiat currencies have on our mediums of exchange.
Okay, that's. Do I have any more questions on the on LBRY? Does anyone have any questions on LBRY before we backtrack, just to give the context for the Michael Rappaport defamation and breach of contract lawsuit? Okay, let me just think of this for 1 second. So they're the next step in this. Obviously, LBRY is going to fight, but.
Oh yeah, I mean the big one will be Ripple. Ripple will set the key precedents.
What is
Ripple? If Ripple wins, that will likely ripple out to LBRY and Odyssey and everybody else.
And I'm trying to think of other platforms now that are using a similar type of.
Oh, there's tons once you really extend the logic, because again, they're saying, did you offer something to raise money for your company and then use it to fund your company? I mean, that's the definition of a security contract. I mean, I don't know if that has any functional limits.
But I mean, I'm thinking of merchandise now. I mean, it in theory, taken to an extreme or an absurdity, or rather just say the logical sequence, selling anything to support the business to the extent that it may appreciate in value, is appreciation of value is one of the criteria?
No, I mean, at least not the way they put out in that complaint. I mean, presumably they'll only apply this to alternative currencies, but logically, the SEC, it's a massive power grab by the SEC, which doesn't have any clear legal limits by their interpretation. I mean, it doesn't meet the traditional definition of a security. That doesn't meet the traditional definition of a contract. Definitely doesn't meet the traditional definition of a security contract. And they're saying they can still do it if it involves fundraising. Are you making profit? Are you fundraising? Are you selling something that we can somehow call a security, even though it doesn't seem to meet any traditional definitions or limits?
All right, well, that's very fascinating. Now I understand the exposure of this complaint and lawsuit. Potential
broad impact. Too few people are paying attention to it.
The bigger question is this also, the SEC as the entity, this is the administrative state. I mean, what the intentions here are obviously for government to centralize control over all currencies and to eliminate any
the same SEC that became deeply concerned about broadly expanding what inside information meant to go after the GameStop folks on Wall Street Bets. That's who these folks are.
Can a company sell a gift card at a discount? They will make rules as needed. No, this sounds crazy. So
they'll lose. I think the courts will reject this because it's too broad, too far, even for the courts to adopt.
But what was the precedent that you had mentioned earlier that expanded the SEC's powers that the ship has sailed?
Oh, the ship has sailed, and then it doesn't have to be a publicly traded stock.
Okay.
Just promote it to the public, which basically is everything.
This feels like it has Nancy Pelosi. Okay.